Good morning, Council. Today's date is October 7th, and the court is sitting to hear one case, Daniel Russo and Danette Gissinger. It's case number 29881. I'm Judge Teodosio. I'll be presiding this morning. Joining me on the panel, as you can see, is Judge Sutton and Judge Callahan. Each party will have 15 minutes to present your argument. The appellant, of course, may reserve up to 5 minutes for rebuttal. And if you would like to reserve time, let the court know when you begin your argument. And Judge Callahan is going to be kind enough to keep track of time for us. Thank you, Judge Callahan. She will let you know as you approach your time deadlines. So again, let us know how much time you would wish to reserve prior to starting appellant's argument, and it could be for up to 5 minutes. The argument, as you probably know, is being visually and audibly recorded, and we are live streaming on the court's YouTube channel. A link to the video will also appear on the court's website. We ask counsel always to mute your microphones when you're not arguing. That minimizes distractions. And while I don't think it's applicable here for those watching, it's always a good public announcement that the court cautions that we do not use the names of victims or minors in oral arguments. Gentlemen, I can assure you that all of the judges on the panel have read the briefs, and we are prepared to proceed if you are. So, counsel for appellant, Attorney Kenneth.
Thank you. By way of introduction, my name is Terry Kenneth. I represent Danette Gissinger, the appellant in this case. And just by way of background, I have have practiced law 44 years next year. Graduated from Akron Law School in '78.
Congratulations.
And thank you. And during that period of time, I've tried more than 400 jury trials around the state of Ohio in more than 30 counties. And I can tell you that without question, the result of this case was probably the most bizarre in my career. And by that, I mean,
Before you go on, counsel, before you go on, I need to know if you're going to reserve any of that time so Judge Callahan can keep track of that for us.
Excuse me, yes. 5 minutes, please.
How much? 5 minutes. Okay, I'm sorry to interrupt you, but that's important.
I should have mentioned that myself. This case, as I mentioned before, is a bizarre case because in essence, it resulted in two verdicts. One verdict was rendered on Friday, January 24th. The other verdict was rendered on Monday, January 27th. It is our position that the verdict that was rendered on Friday, January 24th, at the conclusion of the trial, was a valid verdict and should have been accepted by the court. Unfortunately, it was not. The jury, this was a comparative negligence case. Interrogatories were submitted to the jury with respect to issues of negligence and proximate cause. In answer to the interrogatory regarding negligence on January 24th, the jury found that the defendant was negligent. However, in answer to interrogatory number 2, was the defendant's negligence a proximate cause of the accident? The jury said no. And those same 6 jurors who answered no signed the verdict for the defendant. At that point in time, it was a valid verdict and result for the defendant. Unfortunately, the judge decided that there was a mix-up with respect to the signatures on interrogatory 1 and interrogatory 2, and that the same signatures were not on both. She sent the jury back into the deliberation room to, as I believe she referred to it, reconcile that discrepancy. The jury, however,
the jurors were, excuse me, counsel, the jurors were instructed that the same jurors who answered interrogatory, I think it was A, had to answer interrogatory B, and weren't those jury instructions and interrogatories jointly submitted with the approval of both counsel?
Well, that was one of the issues that I raised in my reply brief. The interrogatories were submitted.
Well, let's start off with the second question. Were the jury instructions and interrogatories submitted jointly approved by both counsel?
No, they were not. and I addressed that issue in my reply brief. The original verdict forms and instructions that were submitted to me on January 3rd, I did not agree to. Another set was submitted on January 9th that did not require the concurrence of jurors to the questions of negligence and proximate cause. However, the set that was submitted to the court, on January 13th was the original first set. So, and I had no hand in that preparation of those instructions whatsoever. So,
excuse me, I'm sorry, counsel, going past that, did the trial judge give both sides the opportunity to look at the final proposed jury instructions that were going to be given to the jury?
Yes.
Okay, thank you.
So the trial court sent the jury back to, as I said, reconcile, if you will, those two interrogatories. When the jury went back in the deliberation room, shortly thereafter, they announced they wanted to go home for the weekend. She allowed them to terminate the deliberations, or the reconciliation, if you will, of those interrogatories, and they went home. They came back on Monday. Now, understand, on Monday, nothing was said to counsel before they began their deliberations again. In fact, we had no contact with the court for 5 hours on Monday, from 9 o'clock in the morning until roughly 2:30 in the afternoon, when it was announced that the jury had reached a verdict. At no time were we informed that there had been a couple of questions submitted to the court by the jury. We learned later that they had been answered by the judge without conferring with counsel, which was, as you know, improper. And then we find out that they had completely changed their verdict. Now they found not only that was the defendant negligent, but her negligence was approximate cause of the injuries and accident, but they then found, in answer to the comparative negligence interrogatories, 51% negligence against the defendant and 49 against the plaintiff, which resulted in the plaintiff's verdict, and the amount of money was set forth in the briefs and so forth. So, in essence, and by the way, in answer to interrogatories on the 27th, only 5 of the jurors who answered the interrogatory with respect to negligence of the defendant signed the verdict with respect to apportionment. So, in essence, what happened here was, on the 24th, a valid verdict was returned that was not accepted by the court. On the 27th, a verdict was returned that was accepted by the court. And so this is the reason why I characterized the case as a 2-verdict case. That first verdict, in which the jury did not find proximate cause and then signed the verdict for the defendant, should have been the verdict that the court accepted. They did not. The court did not. There were a couple of other things that occurred, and I won't belabor it because they're all set forth in my brief. But aside from the court never informing either attorney on the 27th that there had been a couple of questions asked by the jury that the judge answered herself, that went to this issue of the interrogatories, which we found out just before she announced the verdict on the 27th, was highly improper and prejudicial.
Counsel, was an objection made when you found out that the judge had answered questions for the jury?
Not until we had a sidebar following that announcement. When we came to the sidebar, that I advised the court that we had never been apprised of the fact that there were 2 questions that had been asked before the verdict was announced, before the verdict was brought into the court again in the afternoon of the 27th. So in essence, in addition to what I've already pointed out, there were also, during the trial of the case, and this was a highly disputed case. This was a case in which the defendant on a very snowy morning, was on her way to work. Her car spun out 180 degrees, remained in her lane, and she was essentially struck in the front end by the plaintiff's vehicle, which was behind her. So the issue of negligence was a hot issue throughout the trial. And as it turns out, if you look at the answers to the interrogatories, they found both the plaintiff and the defendant negligent, and they found both of them in their second set of interrogatories on the 27th that both of them contributed to the proximate cause of the accident. So there's no issue with respect to this being a disputed liability question. I bring that up to your attention because in some of the questions that were asked in voir dire, on cross-examination of the defendant, and in the direct examination of the police officer, plaintiff's counsel continued to insinuate that this accident was the defendant's fault. Now, I objected to those questions, and many of my objections were sustained by the court. Needless to say, you can't unring the bell. And those questions were put to those witnesses and to the jury itself in voir dire for purposes of, in my opinion, giving the jury the false impression that this accident was solely the fault of the defendant, which, as it turns out by their answers to interrogatories, wasn't the case. In addition, as I've indicated to you in my reply brief, with respect to the jury instructions that did go to the jury on the 24th, the jury was told that if they do not find proximate cause on the part of the defendant, they should return a verdict for the defendant, which they did. The same 6 jurors who found no proximate cause on the 24th signed the verdict on that day for the defendant. End of story at that point in time. They should not have been sent back to consider some, or to try to reconcile interrogatories 1 and 2, because it wasn't relevant at that point. They had answered the interrogatory consistent with the jury instruction with respect to that issue. It was only when we get into what happened on the 27th, in which they, and without any further admonishment by the court with respect to even what they did over the weekend. They got a chance to think about this case over the weekend, and in effect, they changed the result of the case. And now they found 49% against the defendant. So for all of those reasons, but primarily the fact that on the 24th, the jury returned a valid verdict, I would ask the court to return this case to the court and either enter a verdict for the defendant consistent with their answers to interrogatories and their verdict form on the 24th, or at the very least ran a new trial because of all the other issues that I briefed in the case that I'm sure you read and reviewed, warrant that. Thank you.
Quickly, counsel, on the issue of the court addressing the jury outside of counsel's presence, assuming that was error, how were you prejudiced by that?
Well, I mean, if we had known, if we had been apprised of the questions, I might have asked for a mistrial at that point in time, but I didn't, because I wasn't apprised of it. I would have asked for perhaps for clarification of those questions, because they had to do with how many signatures were on the interrogatories that were submitted, the second set of interrogatories that were submitted to the panel on the 27th. But not having been apprised of it, which, you know, as I said, I've tried a few cases in my life. I don't ever remember a judge not apprising the attorney of a jury questionnaire during the deliberation process and answering the questions him or herself without consultation of the attorneys. So I think for both of those reasons.
What was it that was incorrect? What was it that was incorrect or inaccurate in the judge's response to those questions?
Well, I think I addressed
What,
it.
if anything?
Yeah, I think I addressed it, Your Honor, in my brief.
Okay,
Um, number one, the fact that we weren't apprised. Number two, the fact that the questions had to do with the interrogatories and who should sign them and how many should sign them, I think is evidence of the fact that it potentially prejudiced and did prejudice the defendant, because it along with the way they answered those interrogatories, changed the defense verdict on Friday, properly handed down and not accepted by the court, to one on Monday that was accepted by the court.
all right, thank you. How's he doing on time, Judge Callahan?
2 minutes and 42 seconds
Left or in the?
total left.
Total, okay, all right. Attorney Powell?
Thank you. Good morning. May it please the court. My name is Alexander Powell. I have the privilege of representing the appellee, Daniel Russo, in this matter. I'd like to begin by just stating that it would be a complete travesty to justice to permit the reversal of a jury verdict simply because a party does not agree with the result. And I'd like to begin by addressing, I'm going to first address what defense counsel has called the first verdict. On that, and before I even get to that, I'd like to discuss that the jury interrogatories, the first time that Mrs. Gissinger made the argument that this was not a joint agreed upon jury interrogatories and verdict forms was not until the defense filed their reply brief to the motion in support of judgment notwithstanding the verdict. That was never even mentioned or brought up in the first post-trial brief that the defense filed. So when it was filed in the response, the plaintiffs weren't able to file a response and provide evidence. I mean, our perspective, this was absolutely, they were agreed upon jury interrogatories and instructions. They were directly out of OJI. Counsel, we had discussions prior to the filing of the joint ones that, some things were added to the jury instructions, some things were removed. And once the permission was given by defense counsel's office to file the joint set, they were filed as joint. Signatures appeared on the document per the consent from Mr. Keneally's office, Mr. Keneally, that we can file them as joint. And that's what happened. And not only were they filed as joint, but then Mr. Keneally was given several different times he was able to review those. The court printed them out for us, gave them to us, said, counsel, please review these. Let me know if we have any objections or changes, and no objection was given. Then the trial court also read the verdict forms, the jury interrogatories into the record out loud to the jury. And as I pointed out in my brief, the trial court was very succinct and to the point and telling the jurors to please read the directions carefully in the jury interrogatories. And because sometimes only people that have answered the one before it are permitted to answer the one after it, etc. And even after they were read into the record, once again, the defense did not object to the use of those verdict forms and jury interrogatories, which now he claims were erroneous. Then whenever on the Friday the 24th, when the court was notified that there was a potential verdict, the judge immediately noticed that there was an inconsistency in that jury interrogatory, that the jury did not follow the rules that were in bold, that only those jurors that answered A may answer B. When that was read into the record, once again, counsel did not object. The court asked the jury then, rightfully so, to please go back and continue working on these because the rules need to be followed. And even when the judge said, we'll give you a nice, fresh, clean set of the jury interrogatories, once again, counsel never objected. So that brings me to the point of these were joint verdict forms. They were read into the record. They were provided to counsel prior to even being put in finalized form. And it's the invited error doctrine should apply that, these were our jury interrogatories and verdict forms. now all of a sudden, when the verdict doesn't go our way, we shouldn't be permitted to say, well, the court erred in giving those jury interrogatories and verdict forms. And with regard to the second verdict that Mr. Keneally references, the one that happened on Monday, the court, the jury, they came out, they rendered a verdict. They followed the instructions on all the jury interrogatories, A, B, C, D, E, and at no time when the verdict was read into the record did defense counsel request to see the interrogatory forms or the jury verdict form, and no time was there an objection made or any type of inconsistency revealed by defense counsel. And I think that the court put it well that, even if there was an inconsistency, a perceived inconsistency with the one juror Cherry, who signed the general verdict form, but who did not find negligence and proximate cause, Mr. Keneally number one, waived it by not objecting to it. And number two, when looking at all of the jury interrogatories as a whole together, that they were still consistent with a finding of a verdict for the plaintiff. Every single juror, all 8 signed the jury interrogatory that found that the plaintiff sustained a permanent, substantial physical deformity and injury. There were all 3/4 of the jury found the defendant negligent and that she was the proximate cause of the injury. Then almost all the jurors actually found that the plaintiff was also negligent and that he was some cause of injury to himself. And then the requisite amount of jurors found an apportioned liability, according to O'Connell. Those same jurors that apportioned the liability were all the ones that answered, to proximate cause and negligence. So the law was followed to a T. And now after the case has been discharged and the jury was let go, defense counsel raises this inconsistency of juror Cherry signing the general verdict form for the first time. And the court says, while that may be an inconsistency, when looking at all of the jury interrogatories as a whole, it would not be fair to overturn this jury verdict when the interrogatories are extremely consistent with a finding for the plaintiff. In addressing the judge's communication.
What's your counsel? What's
Yes,
your argument contrary to the other side's position that the verdict on the 24th was signed by 3/4 of the jury and therefore a valid verdict? Defense verdict.
I think that one way to look at it is that the jury interrogatory B itself says that only those people that sign that signed A are allowed to sign B. And once there are at least 6 valid signatures on that jury interrogatory, then a verdict for the defense can be entered. And there were not 6 valid signatures on that jury interrogatory. So a verdict for the defendant was not proper. It could not have been entered.
Thank you.
Yes, and discussing the judge answering 2 of those questions on Monday, the defense has not submitted one iota of evidence that the judge's response influenced the jury's decision-making in this case. There's no conclusive presumption of prejudice, as stated by the Supreme Court in State versus Scheibel. The defense has to prove that the judge's ex parte communication prejudiced them, and that the answers were inappropriate, and basically that the judge swayed the jury by her giving her responses. While I don't have the responses in front of me verbatim, my recollection is the judge just basically told them to follow the directions inside of the jury interrogatory. So there's been no evidence of any type of influence or anything of that nature. And especially when the court did notify the parties prior to the jury coming out that there were 2 questions asked. And the court even asked, would you like to review those? You can review those questions before we bring the jury out. And at that time, no objection was made at all by Mr. Keneally. And even when the judge asked Mr. Keneally on the record, do you feel that my answers were incorrect? Mr. Keneally couldn't say yes, that they were incorrect at that time either, just as he basically didn't say that he couldn't say that they were incorrect today, other than hinting that they were somehow, the jury was somehow influenced by her responses when there's no evidence to that. We didn't really touch much on it today, but as far as invoking the plain error doctrine, I don't think that the plain error this is not a case where the plain error doctrine should be invoked. It's only saved for those very exceptional circumstances where, that would seriously affect the fairness, the integrity, the public reputation of the judicial process, and thereby challenging the legitimacy of the underlying judicial process itself. In this case, the only thing I don't understand what Mr. Kenneth says, it was irregular from the beginning. It was a very smooth trial. It was only a 3-day trial. And the only time that it became irregular in Mr. Keneally's eyes was whenever the jury continued to deliberate, doing their job. Their job was to sit down and talk with each other and deliberate and discuss their feelings, the evidence. And because they seemed to have, once the deliberation continued, to make a decision that Mr. Keneally wasn't happy with, then all of a sudden the process became irregular. So I don't feel that the plain error doctrine applies in this case. I don't feel that this was an irregular trial. It was smooth. And I think, once again, when looking at the overall responses of the jury interrogatories, it is consistent with a finding for the plaintiff. And unless there's any questions, I would respectfully request that the court affirm the trial court's decision and decision of the jury.
Any questions, Judge Sutton or Judge Callahan? All right, thank you, Attorney Powell.
Thank you.
And remind me of the time for reply. 2 minutes.
2 minutes and 42 seconds.
All right, that's your reply time. Attorney Keneally.
Thank you. Let me just, again, with respect to this issue of the interrogatories, instructions, and verdict forms. They were initially submitted to me on January the 3rd. The language in that set of instructions required only jurors who agreed on negligence to participate in the response to the question concerning proximate cause. I never stipulated to those. Another set was submitted on January 9th. The new set of interrogatories did not require the concurrence of jurors to the questions of negligence and proximate cause. Only then did I stipulate to that. However, the set that was filed on January 13th was the fallacious set of interrogatories that I mentioned first, that indicated that only the jurors who agreed on negligence could participate in the response to the question concerning proximate cause, to clear that issue up. Secondly, with respect to the verdict on the 24th, counsel's mistaken. The six jurors who answered the interrogatory with regards to proximate cause were the 6 jurors that signed the verdict form. Case over at that point in time. The jurors had followed the instructions, which are, as counsel pointed out, OJI instructions, that if they don't find proximate cause, they return a general verdict for the defendant. They didn't even have to get to interrogatories with regards to the plaintiff's negligence or proximate cause, because they found no proximate cause on the part of the defendant. The verdict on the 24th of January was the valid verdict, and I would ask the court to please return this case to the court for that particular verdict to be adhered to.
Quick question on the some jointly submitted jury instructions and interrogatories. Opposing counsel indicated that the set that was filed had your office signature on it, approving them. Now you're indicating that you did not approve those. Was your signature on as approving them?
I don't have it in front of me, Your Honor, to answer you directly, but my recitation of the sequence of when those interrogatories were submitted, first on the 3rd of January, another set on the 9th, and then on the 13th, the set that was not approved on the from the 3rd was the set that was submitted to the court. Over and above that.
All right, any questions? Okay, go ahead. Does he have time left, Judge Callahan? Yes or no? No, okay. All right. Thank you both for your presentations today, counsel. Very interesting case. The court certainly appreciates you appearing by Zoom video. We'll take the matter under advisement and issue a written decision, which will be mailed to all parties to this appeal. The decision is also posted on the Ohio Supreme Court's website, as I'm sure you both know. With that, the court will be adjourned until October 12th,